have officially opened the AGM. We are now going to move. I will welcome our speaker. I'll explain later why I'm going to call him just Stephen Wildblood today, and I'll be introducing him more fully later. But you are very welcome, Stephen, to join us today. And I will hand over to Mike to do our annual report.
Right, thank you, Tracy. Today I address you as the CEO of the Family Mediation Trust, and will provide an annual report which will cover a slightly longer timeline than we would in most years. In relation to family law, family mediation is a new discipline, having only been born in the early 1980s. The use of family mediation gained momentum with the implementation of the Children's Act in 1989, which encouraged parents to consider mediation before resorting to litigation. The Act emphasised the welfare of children and the importance of parent cooperation in making decisions with a benefit to the child, for the benefit of the child. So it gives me great pride to sit here celebrating the 40th anniversary of the Family Mediation Trust. It was in the winter of 1982 that a group of legal professionals in Norwich got together to explore the idea of creating a non-adversarial way of helping families when divorcing. I'd like to thank these group of mavericks for having the foresight and gumption to follow through with their plans. On the 10th of October 1983, the trustees of Norfolk Family Conciliation Service held their first meeting, and later that year the first mediation cases started. Over the year the service has grown, the name's changed, it's become a charity and a limited incorporated company, and gone on to support countless thousands of individuals. In 1982, in Cambridge, leading academics were also researching the challenges families were facing. Professor Martin Richards and his team compiled the first UK research review of the effect of divorce on children. This research led to the creation of the Family and Divorce Centre, later to be known as the Cambridge Family Mediation Service in 1984. Both the Cambridge and Norfolk services were part of a growing movement. Charity-based mediation services started to appear in most counties to ensure that those most in need could access mediation. At one stage, there were over 25 charity providers of legal aid mediation. Now this is reduced to less than 10. The service played a pivotal role over the years in developing and trialling new approaches to mediation. For example, Cambridge was one of the very early providers of in-court mediation. This work including dedicated research into the effectiveness of an in-court offering. It was only the challenges of COVID that finally stopped the provision of in-court mediation. As I dig through the history records, I'm amazed by the range and depth of work of the two teams. Pilot projects, training, SPIPs, child counselling, homelessness, working in schools have all featured over the years, but it is family mediation that's always remained the main focus of both services. The Family Mediation Council came about in the late 1980s, and from that point started to develop a set of standards. I'm proud that I now sit on the standards board for the FMC and can see that the amazing work of the staff and volunteers do to keep the standards consistently developing to account for the new challenges and opportunities. The biggest shock to the service was the impact of LASBO. This single act reduced the availability of legal aid for mediation, while also introducing the mandatory nature of mediation through a MIAM. The two services increased their range of charitable their reliance on charitable donations to keep them afloat, along with introducing new services and programs. By the time I joined the service in 2019, the two services were struggling, growing overhead set in a climate where fees were not increasing. This meant that staff could not be securing their work and pay increases were unheard of. The economic pressure and the desire by the trustees to ensure the work we did had a bigger impact led to discussions between the two groups of trustees regarding the merger of the two charities. Halfway through these discussions, COVID hit. COVID has been, in some ways, a blessing to the trust. It has enabled us to approach the merger with confidence and modernise how we work, but it's not been easy. The team at the trust have been amazing throughout all these challenges. All through COVID, the trust never shut its doors to clients, The hard work of the team meant that within hours, the delivery had been moved online, paper files swapped for electric ones, and the move to remote desktop rather than offices. The team were amazing. Thank you all. On the 24th of June 2020, the Family Mediation Trust was born, a charity with clear objectives: to ensure that mediation was available to all that needed it, to ensure the service is run in a sustainable way for the future, to ensure that the quality of mediation is as high as it can be, and to act as a thought leader in the family mediation world. So 3 years on, are we achieving these aims? I believe we are, but we can always do better. And I'd like to explore each of these objectives so we can make so you can make your own decision about whether we are. To ensure mediation was available to all that need it. 49% of children living in one-parent households live in poverty. Just think about that. That's a horrific concept, but that against the increasing number of people on universal credit, currently 6.2 million people, the highest rate ever recorded. The cost of living impact on the middle income families, the rise in people using food banks. 3 billion people use food banks. This is 37% up on 2 years ago. These people don't have the ability to pay for mediation, legal advice or counselling. Yet statistically, they are more likely to be separating and use a family court system. We must ensure mediation remains at all times accessible to these families and children. But during these times, the number of providers of legal aid has dropped by 56%. So to us, the major element of being accessible to all is ensuring that people in the extremes can access our service. Since the merger, the number of cases relying on legal aid has increased to 68% of cases. The number of cases we apply our reduced fee rate to, these are clients that earn less than the real living wage, has continued to increase. And the threshold rate is raised annually in line with the real living wage to enable more families to access it. Over 40% of the legal aid cases make use of the voucher as well. With thanks to Cambridge Community Foundation, we have a grant fund available in Cambridgeshire for the cost of the child inclusive mediation session and to support families with children that have special education needs. We have extended our reach and provision to enable more families from a greater area to access mediation. These are mainly areas where the legal aid contracts have been dropped by other providers. And we have joined the coalition to end child poverty. But we aim to provide mediation to all. That's not just to those on a low income. While the above highlights a commitment to those families on low income, the Trust also serves an increasing number of private fee-paying clients. The complexity in these cases has not become easier. The team work with many legal practices to support their referrals. And increasingly, we are having legal advisors join into the mediation sessions. I'd like to take this opportunity to thank the legal professionals, charities and other mediators and CABs who refer clients to us every single day. To ensure we are sustainable into the future, we can only support families if we have a structure and process that is sustainable. To this end, we have been working fastidiously to ensure we spend money on the things that matter. This is a team of amazing mediators and administrators. Mediation is about people. Through ruthless control of overheads, a focus on spreading costs over greater client numbers and improving client conversion rates, we've been able to increase the Trust resources to a point which enables the team to have the job security for the future and to enable the Trust to have the confidence to invest in trainees. Unlike most mediation providers, the vast majority of our mediation team and all our administration staff are employed by the Trust. This means that introducing an annual pay review, introducing enhanced sick pay policies, increasing holiday pay, and introducing mental health and wellbeing support has impacted on everyone. One element I'm most proud of is the signing of the real living wage. This ensures that not only now, but in the future, staff have the security that their pay will not be left behind. To ensure that the quality of mediation is as high as it can be. How do we measure quality? This is a fundamental challenge of mediation. If we look at the conversion rates in agreements, or how many MIAMs convert to mediation, then we are seeing year-on-year improvements in each of these metrics. If we look at the net promoter score of our clients, then we're regularly benchmarking at over 35. To those who aren't accustomed to these metrics, this places the trust above sectors such as hotels, insurance, and banks. To achieve these rates, the trust invests heavily on staff training and PPC support. We have two amazing PPCs in Craig and Jane. I'd like to thank them for always being on hand to support the team when needed. But I suppose that the real test is in the depth of the impact we have on families. So when we get emails from clients unsolicited, such as the one on the screen, it makes us feel as if we're delivering a service that does have meaning for our clients. To act as a thought leader in the family mediation world, mediation is a profession that has grown up a lot over recent years, but it still feels at times like an unruly teenager. There is a lot for the sector to explore regarding its own identity and how it fits with the world. The work the Trust is doing in regard to the thought leadership is focused through our Centre for Excellence. Over the past few years, we have trained over 300 CAB and other charity sector staff in an introduction to mediation course, hosted conferences with Judge Cobbs and Professor Gordon Harrell to explore topics such as mental health in children and domestic abuse, hosted a debate on the question of whether mediation should be compulsory, which we know has been used in policymakers in more than one country, invited a range of partners to observe mediation. This includes the Children's Commissioner, domestic abuse charities, law centres, and many more. We've delivered a broad range of training courses to mediators, set up a pilot project with thanks to the Norfolk Community Foundation and the Mercer's Charity to explore the role of parental coordination as a vast, viable post-agreement mediation option. This programme is seeing clients from across Norfolk accessing reduced fees and free parental coordination support. The results of the pilot are due in around 12 months' time, and we're excited to see how we can develop this post-agreement mediation model into the future. Low Income Champion. Working with other mediators, the Trust has been instrumental in setting up the Family Mediation Legal Action Group. This group is working hard to ensure legal aid remains accessible and available to families across the country. As the chair of the group, I'm highly thankful to the hard work and support of the other organisations. As we explored the issue further, it's become apparent that the group not only need to focus on the important issue of legal aid, but also on the general issue of supporting low-income families through their separation journey. This group have very few advocates when it comes to policy formation, but as we discussed earlier, this group need our help. To this end, we are on the cusp of launching a brand new website, Mediation for All, that will help raise a profile and challenge challenges low-income families have when divorcing and separating. The site will also help make it easier for families to find legal aid providers. It would be amiss if I did not thank Freddie from Calm Mediation, our co-chair, for the help on this project. One of the challenges mediators have is the ability to influence social change. When couples separate, the majority don't want to fight, but movies, the press, friends, trusted advisors all encourage the use of courts and the need to fight for your rights, justice. This leads far too many cases to a court rather than mediation. And for many that do come to mediation, they come to mediation with the perception that it cannot work. We need to find more champions for mediation. The Trust has launched, as part of its 40th anniversary, a target of creating 100 mediation champions. These are people who work directly or indirectly with separated families and children. We want to encourage a low conflict approach to mediation. We have already trained 25 amazing champions and have a further 75 booked in for future courses. So that's 100 achieved. Yes, but I don't believe that's good enough. Let's increase the target to 500. If you would like to join this growing list of mediation champions, please book a place on the free courses over the coming months. That's a pitch over. So from the above, I hope you agree we are working hard to fulfill each of our objectives. We have so much more to do. Plans are already underfoot for a new conference in February. I want to finish by looking to the future. The world of mediation is on a cusp of maturity. Think of it as coming towards its 21st. We need to be planning both for a party and for a future life as an adult, fending for ourselves. Will the government make mediation compulsory? I don't know, but I do know they will be sending a lot more work to mediation. Are we ready? We know that divorce rates will continue to drop, but the number of people separating and living in co-parenting relationships and the complexity in separating families will continue to rise. Are we ready? We know the skills mediators need will grow and the challenges clients throw at us will be increasing, challenging both the mediator's skills and mental capacity. Domestic abuse, autism, coercive behaviour, parental alienation, all are just a few of the challenges we see on ever increasing numbers. These trends will not stop. Are we ready for them? We know that technology will play an ever increasing role in families, divorce and separations. Do we understand these opportunities and risks? 40 years from now, what will the world look like? Are we ready? We know that children are struggling with mental health issues and that a lot of these could be rooted into the separation process. The skills and approach mediators need to use to ensure the child's voice is central to the process must be developed. As a mediator, are we ready? 40 years in the future, what will mediation, separation and divorce look like? If we are not ready now, what are we each doing to get ready? What are we doing as a profession? These are the important questions as a team, our team and trustees are thinking about.
Well, anniversary lecture. It's there. So I made some reference in my welcome because if we'd held this meeting on Monday or perhaps Monday morning, I would have addressed our speaker as His Honour Judge Wildblood, KC. However, he retired on Monday, so he is now simply Stephen Wildblood. It's a lot easier for us all. But so who is Stephen? Well, he was called to the bar in 1980. He took silk in 1999. He was appointed an assistant recorder in 1997, a recorder in 2000, and as a judge of the Mental Health Review Tribunal in 2007. He was authorised to sit as a High Court judge in 2004 and appointed as a circuit judge in 2007. And he has served as the designated family judge for Avon, North Somerset and Gloucester since 2013. He was also a family course tutor for the Judicial College and a faculty tutor until now, recently. But Stephen's commitment extends far beyond the courtroom. He is a prolific author and an esteemed lecturer in family law. His passion for supporting those navigating the legal system has led to the establishment of various initiatives in Bristol to assist individuals representing themselves. A remarkable aspect of Stephen's character is his unique approach to daily life. He was not your typical judge. He would start his day with a run to court, accompanied by trance music, which set the tone for his unique day. This reflects his unconventional dedication to championing the rights of disadvantaged families. Stephen has been open to media engagement, highlighting the growing issues of individuals appearing in court without legal representation. He actively involving himself in initiatives including legal education classes and free consultation evenings designed to empower those navigating the legal system alone. In a legal landscape where many cases involve individuals without legal representation, Stephen strove to get the level playing field. He understands the emotional weight of decisions, especially when he had to decide about parental access. His advocacy extends to early intervention and support for parents before their situation escalates into the courtroom. Stephen's dedication to justice is reflected in both his professional and personal life, where he had been juggling his responsibility as being a judge and a devoted father. His journey and commitment has set an inspiring example of being a compassionate judge dedicated to making a difference for family and children in times of transition. And his legacy as becoming a mediation champion will continue to inspire all who encounter his story as he moves to this new part of his career, to become a family mediator. He'll be working with the clinical psychologist, Dr. Frida Gardner, offering people from all walks of life an alternative to litigation through the family court over issues relating to their finances or children. So that's Stephen for you, and over to you, Stephen.
Well, thank you very much indeed for that introduction. I feel full of trepidation as I speak to you. And I say that for a number of reasons, but in particular this, that yes, I was called to the bar at the age of 21 in 1980, and I have worked within the family law system for 44 years. And I've had the real privilege of serving as a circuit judge for 16 years and being the designated family judge for 10. But I've made the choice deliberately to leave that privileged position and to try and find if I can contribute to a better way. And that's why I've called this talk A Better Way. I've just been to to another conference where I've listened to a succession of speeches, and actually at the end of them I was left thinking, what points do they make? What points do I carry away? And there are only very few. I do want to begin, therefore, by making a few succinct points, and the first is to thank you for what you're doing. I don't think that we thank each other enough, and I don't think that mediators realise just how much of a contribution they make. But you do, and it's a very important one. And you'll understand, I hope, why I say that as I move through this talk. But if there's one thing that I would ask you to take away from my talk is to hear that thanks. The second point is to express the admiration that I have for the work that you do. How much do I admire it? Well, I admire it enough to want to join you and to give up the privileged position that I have held and that I've just described to you. I have probably more personal commitments than most. I have 4 teenage children, 2 older children and 3 grandchildren. And so to step away from a secure job with a secure pension and a regular income is a major step for me. But everything in life is temporary. And we all need to remember that. We think that what we're doing at the moment is enduring, but it isn't, and things change. And so I made the decision that I wanted to work in accordance with my belief and conviction. And that has taken me to the point where I want to emulate the work that you do. That's how much I admire it. The third point is that in talking to you, I'm going to make some comments. I do so as a novice. It feels a bit like changing school. You stay at the school for a while, you reach a certain point where you are one of the oldest children in the school, and then you move, you start again. And that's where I feel I am. So if I do say things that you disagree with, then yours is the voice of experience, not mine. I hope, however, that I can cover some of the things that I've seen in my past roles, and that they will be helpful in the development of the important public service that you provide. So I'll just turn to the next PowerPoint if this is working. Yeah, I got up at 3 o'clock this morning. I'd written to Mike to say I'm not going to do any PowerPoints. I'm personally sick to death of going to lectures which seem to me to be death by PowerPoint experiences. But I ran out of confidence at 3 o'clock in the morning and got up and bashed out these PowerPoints. They're no great work of art. They're only an outline of what I'm going to say. But I want to talk about the court-based culture, because I believe that is what we still have. Even though that is the case, and I'm sure it is, having seen how it works, there is capacity to change the system. And that does not relate just to private law. And I want to cover in this talk private law, children, finances, and I also want to touch on public law, because there's something that I'm doing with Dr. Gardner that may interest you. But I want to deal now with this meaningless phrase that is used, quasi-inquisitorial or quasi-adversarial. In my opinion, there is no such thing as quasi-inquisitorial or quasi-adversarial. The thing is either adversarial or it isn't. And I would respectfully suggest that however much we might try and bolt on things to our present system, it is, bottom line, adversarial and is based on an adversarial model. I can remember being in a court and watching a colleague from Chambers getting exasperated by a particularly bovine judge who simply could not get his head around a straightforward point of law relating to housing. And in the end, my colleague did the unforgivable thing of losing his temper with the judge, flung his papers down on the bench in front of him, waved his hands by the side of his body, and said to the judge, "But it's so simple." There was then an explosion, as one might expect. But would it not be so simple to change the private law procedure into one that is inquisitorial? And that's what this next slide is about. I could have done it if I had the skills by way of a flow chart, but I'm afraid at 3:30 in the morning, after I tripped over the dog, much to his disgust, I didn't get round to doing it. But imagine this. Imagine mediation has not either taken place or worked, and the application is made to the court. The first thing that is essential, of course, is that there is safeguarding information. The court knows nothing about these people except what they say. And it is a very foolish judge indeed who starts making any decisions at all without basic safeguarding information that's provided by the police and children's services, where they have information to give. But then the next stage is what at the moment is that mouthful of a court hearing, the FHDRA. Why is that not a mediation-based hearing? Judges will say that it is, and will pretend that they have the mediation skills to run it as if it were a mediation. Very few judges I know have trained as mediators. And I know, having trained twice as a mediator now and practiced as a mediator when I was at the bar, the mediation is not about being nice to people, nor is it something that is a matter of the personality of the mediator or judge. It's a skill. It's an art. I learnt most recently how skillful it was when I was trained by Jackie Norton at FMA, and to her I have a huge debt of gratitude that I'd like to express, because it is a skill, and that first court hearing is so important. I don't understand why it isn't more mediation based. But if the case doesn't resolve then, would it not be straightforward to divide the procedure into two tracks? If there has to be a fact-finding track, let it go to the fact-finding track and let there be a written judgment at the end of it. If there isn't a fact-finding hearing, then it could be put into the reporting track, where you get a CAFCAS report or some other reports, some other information as to the welfare of the children. If there is a fact-finding hearing, then it comes back into that track at the end of it. And then, and this is the main point I'd want to suggest, then there is a final hearing which is inquisitorial at what at the moment is called the dispute resolution appointment stage, the DRA stage. And that's the end of the proceedings. And you'll see I've said the Danish system. Well, it is at that point that in Denmark, for instance, the parties are called before the judge, and there's a panel of judges, including local, as they call them, politicians, the equivalent of magistrates, and in some cases a psychologist. The panel has read the papers. The parents are able to address the panel for a short while. There's no cross-examination. And then a conclusion is reached and a judgment is given in writing. I just don't understand why we don't adopt a similar process to that. The idea in this day and age, with so many people appearing as litigants in person, they should then go to a final hearing where they're expected to cross-examine each other, is, I think, antiquated. The next point that I make is this: can all private law, as I'm calling it, cases be mediated or resolved by ADR? Well, of course not. It has to be recognised, I accept, that there are some cases, for instance, involving domestic abuse, where injunctions are needed, where people won't engage, or where they choose to litigate. It is simply not going to be possible to force them through mediation. There's a massive debate, I know, about whether mediation should be compulsory. I'm too much of a novice in this area, I think, to comment upon that, and I would leave that to you, because you will be wiser than I could be on that issue. But I accept that there must be some cases where mediation cannot take place. But, and this is the next slide, I want to talk about cost. I have recently done a case where the mother's cost allowance was over £15,000 a month. I won't give the precise figure. And also, she was given a lump sum. The father was ordered to pay a lump sum to her of over £100,000 in addition to that cost allowance. And the issues were, how much time should the children spend with each of the parents, and which school should they go to? I just can't understand how that occurs. And of course, it's very easy to say, oh, well, these are litigious people. And how does the system allow that to happen? I want to mention another case where the parties were rich but not super rich. Their assets were less than £10 million. And their legal costs in combination were £1 million, just over. And the issue was, how much time should the children spend with the father? It wasn't the principle of contact, as lawyers tend to call it. It was the quantum of contact. How much time? How does a system create that amount of legal expense on an issue of that kind? So although people sometimes talk about the limitations of mediation, that has to be balanced very strongly against the considerable limitations of the alternatives. What about delay? I think average duration of private law cases is 44 weeks. And if that's the average duration, bearing in mind how many cases resolve themselves at a very early stage, for instance, at the FHDRA, it means that there are many cases that go way beyond that 44-week period. 44 weeks of itself is a very long time. They're not just cases. These are not just cases about how much, where the children should live. These also involve cases about whether a parent should have any contact, to use an outmoded phrase, with his or her children. And that is a long period in the life of children, particularly young children. So delay within the court system is a real problem, in my opinion. And what about volume? Well, I looked at the CAFCAS statistics in the early hours of this morning, and I found a 17% increase in private law between 2018 and 2023. Some inroads have been made in relation to public law. As you will have heard, the numbers are at last beginning to steady, if not slightly decline, in recent months. But perhaps unsurprisingly, following lockdown and COVID, the numbers of private law proceedings, as I understand it, are increasing. So you have a super stressed system, a system that was already highly challenged before that increase occurred, now seeking to bear that additional burden. And what about the effect on families who get caught up in that? When people separate, they separate because they feel their relationship cannot continue. The whole family is under immense strain. They are then pointed towards the millstream of litigation. And if they were on bad terms before they came into that litigation, by the time they come out of it, they will be significantly poorer and significantly more stressed. One of the other real concerns I'd suggest at the moment is the potential for the development of a two-tier system, for the court system to be there for those with legal aid, for those who are either in abusive relationships or alleged that they've been in abusive relationships, and those who are just downright obstinate. Those who can't pay for arbitration or mediation go into the court system. That's not what it's there for. And that's not a good system, in my opinion. So that's part of the reason behind my decision in what I'm doing and why I'm doing it. I just want to talk a bit about the symbols of the adversarial structure to underline what I'm saying. I ask you to think about the terminology that we use. We refer to people as applicant and respondent. The procedural structure is, I would suggest, essentially adversarial. You make an application and there's a response to it. If you can't settle the case at the first hearing, there are statements. And the statements do not include the nicest things that are said about each other, of course. Because, as I say here, in my opinion, a lot of it is focused on the negative. The underlying legal framework is also, I would suggest, essentially adversarial. There is a burden of proof on the person who alleges an event occurred, and a standard of proof. If you reflect, as I have, upon the process of seeking to discover the truth by contested hearings, it is a very complex concept. That by having everything tested in that environment, a judge is expected to reach a decision that is sound. Whether or not it's the truth is another matter entirely, and I'm not going to fall into that trap of seeking to suggest that the purpose of litigation, whether a contested issues of fact, is to reveal the truth, because the truth is a much more complex concept. Much of what I was doing involved finding of fact hearings where what I was discovering was where the probability lay. If it is right, as I think it is, according to the statistics I've read, that 80% of private law cases involve a litigant in person, how are litigants in person supposed to conduct themselves? Are they supposed to behave like Perry Mason, and can they do it? Very often they do not know, of course, how to operate. And it was a great shame to me that some of the charitable endeavours that we set up in Bristol just collapsed through lack of funding. Things like the personal support unit, as it used to be, support through court. The multi-faith support group that I set up, that's collapsed. And that's a great shame, because people turn to faith when they are facing the greatest adversity. Even the Pause project in the private law arena has stopped functioning, despite the years that it took me to set that up. Lack of funding. One of the other effects, I think, of the system that we have is that there has developed a really unhealthy and unhelpful conflict between, on the one hand, those who emphasize the importance of domestic abuse and recognizing the effects of domestic abuse, and on the other hand, those who advocate the importance of parental alienation. I was trolled repeatedly in my former job. If I decided a case one way, then I was supporting somebody who was engaged in parental alienation, it would be said, or if I allowed a parent to have contact with a child in the face of allegations of domestic abuse, then it would be suggested that I had not recognized the true aspect of abuse. And that unhealthy division, I think, has developed in particular recently, and is a problem. I'd like to now move on to look at this phrase, ADR, alternative dispute resolution, because I don't like the phrase myself, and I'd like to explain why. First of all, the first word, alternative. Alternative to what? Does our use of that word leave the court system as appearing to be mainstream? One of the reasons I don't like it is that there's this phrase, the alternative society. And I think there is an element of that in our use of that adjective in this way. But the real difficulty I have is the word dispute. If you think about what it is like, what it would be like to separate from somebody and to have the complexity of trying to sort out arrangements for children and money, and not being able to do that. What you don't want, I would suggest, is to be in dispute with each other. What you want is help. You want help sorting out the arrangements for your children and sorting out your money. And those arrangements may be very complex indeed. So I would suggest that dispute is the one thing that separating couples ought to try to avoid, and many do. And we don't do them a service by suggesting that we're engaging in alternative dispute resolution. And as to resolution, does it emphasize a system that is too outcome driven? One of the biggest words of advice I heard, best words of advice I've heard from a judge I admired hugely, Her Honour Judge Hazel Council, was look at what you want to achieve and work backwards. And as a lesson in life, that is wise, but it's also, I think, helpful when considering family issues that we are discussing at the moment. But there is more to what families need than just getting an outcome. That is why I'm working with a psychologist in the future, Frida Gardner, and we intend to work together, not just on achieving outcomes, but also leaving people intact, we hope, at the end of the process. Another word of advice I had was from a former CEO of an international charity. And he said this: it is probably worse to be misheard than not to be heard at all. And I think that is true. If you turn to somebody for help and they mishear what you're saying, you go to a doctor, you've got something really troubling you, and the doctor doesn't pick up on what you're saying, actually getting to the doctor and saying what's happened is immense, and then to be misheard just adds to the burden. It worries me that too much of a focus on outcomes can leave an awful lot unheard, and that's not to confuse mediation with counselling. What I'd like to move on to next, please, are the two main types of, as I'm calling it here wrongly, ADR. Arbitration and mediation. Are there others? Of course there are. And there is a growing field of early neutral evaluation. It is an example of something that is building up. I'm going to train as an arbitrator. I'm on an arbitration course next week. You can't train or apply to train, in fact, whilst you're still a judge. So I've just scraped onto a course. But one of the concerns is that arbitration is going to become the sort of private hospital equivalent. That those who can will choose an arbitrator, a retired judge or someone else who they feel has particular experience in the field, and they will want to pay that person to adjudicate on their case. And those who have the money will be able to do that. And I'm quite sure that that is going to develop in the future. There are limitations in relation to arbitration. It won't take, arbitrators won't take cases where there is significant domestic abuse. But what incentive is there going to be to avoid conflict for those who do not get into arbitration? A C100 costs £232. And once you're in the system, you're in it for as long as it takes. And I just wonder whether that of itself isn't part of the problem of the court's burden. At the end of the day, those who can afford it, why would they not mediate? As I said, you choose the judge. The case is resolved without delay. The arbitration can be issue focused. There are clear expectations. And now it has been decided by a number of cases. The parties can, in effect, appeal the arbitration decision to the court under procedures that are not dissimilar to that which would apply to an appeal against a judge's decision. I'd like to talk now, please, about some of the benefits of mediation in relation to children. The first matter I've mentioned is autonomy. Whose children are they? With 6 children of my own, the idea that somebody else, a complete stranger who I've never met before, should make a decision about my children and impose it on my family is totally alien. I've never been in that position and would never want to be either. If I got stuck, I would want somebody to help me through the stormy waters that I was facing and can arise for any of us. I would hate to have someone impose a decision on me. And in providing mediation, you help people to retain their autonomy and you afford them the respect of the fact that they, not you, are the parents of these children. And that's why I've used this word integrity. That's a word that's taken quite a lot of challenges in recent years in the way that it gets used by a number of individuals. But mediation allows people to remain intact as individuals, that they can leave the mediation process and feel that they have retained responsibility for their lives and the lives of their children. Mediation can also be flexible. It can be considerably less expensive than the sorts of cases that I've referred to. And it can also have a specific focus. People can bring issues that they need to discuss to the mediation table and have them have the discussion facilitated by the mediator. I would also suggest that mediation is better suited to meeting the needs of diversity and inclusion. There's some very interesting research that's been done by somebody called Professor Frank Dobbins at Harvard University. He investigated over 800 large organizations in the United States, and his research continued over 30 years. And the point that he makes is that engaging in diversity and inclusion training, whereby management try to teach the workforce, like judges at first instance, being the workforce, the meaning of bias, how to avoid lack of diversity and lack of inclusion, that does not have any long-term effect. The only way that the need for diversity and inclusion becomes embedded in a system is to address the systemic issues that lie behind the need for diversity and inclusion. And it is that systemic approach that the Harvard University research promotes. And I would suggest that with the training that you've had as mediators, and because of the system that you've put in place as mediators, you are best able to meet the needs of diversity, including neurodiversity. I'd also suggest that mediation provides a system that has more depth to it, because the parties are able to explore things that matter to them rather than being channeled through litigious procedures. What about finances? I practiced for 17 years, was it, as a junior barrister doing financial work. I've written in over 20 legal textbooks. And I started in the 1980s, in the days where financial cases were a bit like being on a horseback with a jousting stick. Some of that, of course, is gone now, but a lot of cases, when I started, went to court, and they were definitely adversarial. So I've seen what it's like. And I am, after all, the judge who started one judgment recently, and it's been published, describing the proceedings as feral, unprincipled, and disproportionately expensive. I think the word feral is going to be painted onto my gravestone if ever I have one in the future. But mediation in relation to finances, it is non-oppositional. People engage in self-determination. They can determine themselves how their finances should be divided. It is much more cost effective. And I do wish that message were to be better absorbed. People do not understand when they start litigation how much they are going to spend. And it's a bit like climbing one of those hills where you keep on coming to a peak and think you've got to the peak. I'm sure people feel, well, we'll just get to this part of it and things are going to settle. And then things don't settle. And so the climb to considerable legal expense continues. I also think speed is important, and speed favours mediation. It's not that I'm suggesting it's a process that is forced through. It isn't at all. But a mediator can resolve finances in accordance with a timetable that is agreed. And I do consider that delay is a huge enemy to people being able to move on with integrity. And also depth. Again, the issues that the parties want to bring to the table can be addressed. Mike has spoken about poverty. 49% of single parents being in poverty. most of the cases, most of separations involve people who are not the super rich. There's one house, 2 children, for instance, 1.5 jobs, and the cost of living crisis that they're trying to deal with. It's a struggle for most people to keep going when everything is combined. The idea of splitting highly stressed finances into 2 households is terrifying. What do they do? And how many of them just give up? How many, for instance, fathers give up on contact? We did some calculations in Bristol and the figures were huge. So poverty, whether we like it or not, is a real problem. And those who can't get legal aid cannot be expected to litigate as if they were lawyers. I'd like to move on because time is nearly up on what I'm going to talk about. Is why is mediation not more embedded? And this is me treading very carefully on this because you are the mediators. I think the power and strength of the court-based culture. It's a very powerful system. I think the removal of legal aid and people becoming streamlined into the court system and not understanding how to get into mediation. I think in many cases, people separate, there's an argument, the court-based culture kicks in, they go to court, and once they're in that, it's a fast-flowing millstream. I think the MIAM has not taken off, and there's a lot said about that, and there's the consultation process that you'll all know about. But I wondered to what extent a MIAM has been a tick box process, and whether people have actually heard of the voucher scheme. I've heard the figures that Mike's given. But I do want to suggest, please, that there is more that we could do as mediators. I have striven in my role as DFJ to get mediators in the Bristol area to unite. And I've had many meetings, suggested many ways in which the mediation service could get out into the community and promote itself within the community. And in the end, I have to say, in the Bristol area, I gave up. I just was not getting the support for that I had hoped for. And I'm sorry about that. And I'm sorry to sound critical. But I did spend a lot of time trying to do what I think, Mike, you've done in your area, and which I admire so hugely. And please don't lose that. Mike, you were the one who set up a debate about mediation, and you were kind enough to ask me to be involved. But taking mediation into the community so that the community understands what it is so important. Solicitors are very good, and barristers are very good at promoting, at publicising what they do. I do think that mediation, if I may say, is missing a trick by not promoting itself sufficiently within the community. And having conferences for professionals is lovely. But what about conferences for the public? What about the equivalent of what we did in Bristol? It's your family court, what could we do better? And we had members of the public, usually about 100 people, coming to those and contributing and feeling engaged. I think my time is probably now up. Is that not so? I was going to talk about domestic abuse and mediation and the significant harm test, but maybe we can come on to that. I was also going to talk about specialist money mediators.
You've got a little bit longer. You can have a few more minutes. Okay.
Well, could I then talk about public law and just lay down a bit of a challenge in relation to that? So we've got 26 weeks. About 15% of public law cases end in supervision orders, I think. Why has it not been possible to introduce a form of mediation between local authorities and families that is akin to the settlement conference idea that is used in Canada and in many of the states in the USA. So, at a stage when the court has got nothing to do with the case, not in the pre-proceeding stage, not in the proceeding stage, but in the non-proceedings stage, when the court is not involved at all, why have we not developed a system where there is a settlement conference involving the local authority and the family, for instance, where there is a child in need plan or a child protection plan and the family is not responding as the local authority want? Why do things then not move into the greater formality of a settlement conference with somebody who's trained in mediation and can help the local authority and the family concerned produce a proper and carefully worded schedule or memorandum of understanding or schedule of expectations, call it what you will. I firmly believe that a proportion of cases could be stopped from coming to court at that stage. And Dr. Gardner and I are working with the local authority on that. Of course, local authorities have no money at the moment. But if that system were to be put in place, the savings of money are obvious, I'd suggest, and the outcomes would be far better. Once a case is in the public law system, it sweeps along. And any idea of therapy coming into effect and being tested during the 26-week period, I'd suggest it is an unreasonable expectation. So we're working with the local authority to set up a pilot scheme to that end. And I believe in it emphatically. I hope it takes off. We're doing some research in relation to it, and we will be publishing that research. I'm going to end there. I'd like to thank you for listening, and I'd like to end there on the note that I began, and that is to thank you for what you're doing, and to repeat, so much do I admire your work that I've taken the plunge that I have, and I hope that I'll be able to contribute to the work that you do as a mediator. Thank you.
Thank you, Stephen. We have had one request, which is, could you give us your thoughts on the domestic abuse? So do you want to just quickly cover that, and then we'll open up a proper question session?
Of course, yeah. I think I need to press stop presenting, don't I? So then the presentation. Yeah. Is that stop sharing? Okay. Thank you. I have prepared a slide in relation to that, but ignoring what I put on the slide. I fully understand the difficulties that arise where there are allegations of domestic abuse within, and it is suggested there should be mediation. Quite obviously, it is essential that people, when they engage in mediation, feel safe and able to discuss things. I think it's also important to recollect that at the end of the mediation process, however much people may have behaved better during the mediation sessions, they then go on to live their normal lives outside. And if there are aspects of abuse within their relationship, even though they may not arise or be played out in the mediation sessions, they may continue, they're likely to continue outside. So it's a big problem, and it's not an easy one, but I do question whether the exclusion of all cases involving all forms of, or all cases where there's been some form of significant harm in the or harm in the past, whether those should be excluded from mediation. Domestic abuse is not just domestic violence. It's not just physical abuse. It's not just sexual abuse. It also includes emotional abuse. I think emotional abuse is very difficult to identify in the initial stages, and it takes time to really understand the underlying dynamics of a relationship. I do question whether there is an opportunity to use shuttle mediation and to use remote mediation over Teams and Zoom more, and whether it is right to exclude all cases where there has been where there are allegations of domestic abuse. I am particularly interested in hearing other people's views about cases involving emotional abuse. So I'm not convinced myself that all cases where there has been a suggestion of abuse should be excluded from mediation. I'd be interested to hear whether people feel there is a distinction to be drawn between those cases where, at the time of separation, a couple has experienced some form of domestic abuse. There's been a blazing round, somebody's thrown something, or there's been physical abuse at that stage, but there's no underlying pattern of subordination. And whether that can be viewed separately to those cases where the domestic abuse is an ingrained part of the relationship. But I'm treading on that very carefully, because you're the experts, not me, and I don't want to come across as someone who's speaking beyond his brief. Okay.
Thank you, Stephen.
I want to say on that issue. It's a very complicated point.
I'm sure we're going to get into it in a second as we open up to a question discussion. To help on the discussions, we've brought in Jane and Tracy. I'm going to ask each of them just to introduce themselves briefly in their roles, and just give us any points they've picked out from Stephen's presentation that made them think that sounds interesting. And then once we've done that, any questions can be put through the chat, or raise your hand and we'll get through the questions and see where we go. Jane.
Hello, Mike, and hello, everybody. Hello, Stephen. First of all, I just wanted to say, what a wide-ranging, illuminating, inspiring, challenging talk that was. And Mike asked me before this meeting to pick up on one issue, perhaps to focus on in terms of my input. But there's so much there that, I would want to have a long conversation with you about. And of course, time doesn't allow that. Just to introduce myself, first of all, my name is Jane Bridge. I was also a barrister, called to the bar in 1981, so the year after Stephen, and practiced for 20 years at the bar. First doing bits and pieces of everything, and then focusing on family law towards the latter part of my practice. And like Stephen, I was interested in the title of your talk, A Better Way. When people asked me why I'd left the bar to become a mediator in 2000, I said it was because I felt there must be a better way to support families through breakdown than negotiating at the court doors at the last minute, in a very costly hearing, at a point where I felt that if I had reached these people 2 years before then, I'm sure I could have helped them to make a difference and to avoid that situation. So that's what drove me away from the bar in 2000. And I joined the what was then the Cambridge Family Mediation Service in 2002 as a trainee mediator. I'd done actually my training in 1993 with Lisa Parkinson as one of my trainers, and Angela Lake Carroll and the late Robin Apsonen. And I'd been, as Stephen was, I think, also mediating alongside my practice for 7 years or so before making the jump sideways into mediation. And joining the mediation service in 2002 as a trainee mediator, in other words, working towards accreditation and working on the wretched legal aid agency portfolio, which I wrestled with for a number of years and finally got through, I realised that I've now been around in the service for its 21st birthday, its 30th birthday, and now, shockingly, its 40th birthday. And so it's made me realise how old I must be. I became a PPC in the early 2000s, I think, in the service, and it's been my very great privilege to support mediators through mediation practice, the accreditation process, and so on over the last 20 odd years. And I have to say that, I never looked back once I made the decision to move careers. Looking, at the points that Stephen so lucidly and candidly, raised, I think that there are several kind of standout points. I mean, one or two I'd like to just make a couple of more observations about. The first was that I felt that the piece of advice he'd been given about people feeling that it's worse to be misheard than not to be heard at all was absolutely, hit a chord with me, struck a chord with me. And I think that if we could put that at the sort of nub of what mediators actually do, that would sum up quite a lot of our job. And I think it's why the mediation training is so important and why the accreditation process in due course is so important, is that ability to actively listen, to acknowledge and to validate people's points of view without necessarily agreeing with them is a sophisticated and complex skill, and it's something that takes years, I would suggest, to learn properly. And I'll hold my hand up. I think it took me 7 years to make the transition from being a barrister representing one party at a time to being a mediator who could genuinely try to sit back in a balanced and as neutral and impartial way as I could to hear what people were saying and to be able to think on my feet sufficiently quickly to pick up whatever strategy or skill I might use to help them to move from where they were to a place where they hopefully would prefer to be. And I think that training and accreditation as a mediator, it enables us to make that transition so that we don't run the risk of staying stuck in our previous professional roles. I think it's so easy, perhaps, to step into mediation and to end up with it just being another way of us telling people what to do or advising people what we think is best for them, when we actually have to take that step back and to allow them to progress with self-determination and to give them the autonomy over making the decisions that are best for them and their families. And I think nowhere is that highlighted more than in Stephen's remarks about the benefits of mediation for children. And, personally, I'm delighted to see the way that child inclusive mediation is being promoted, encouraged and practiced more and more frequently now, giving the child a real and direct voice within proceedings where, of course, that's appropriate and safe. And again, that screening for child inclusive mediation, just like the screening for domestic abuse cases, is an absolutely crucial skill and a crucial part of what mediators learn to do as part of their training and accreditation. And I think, looking at the issue of domestic abuse and in covering it in all its forms, whether that be psychological, emotional, physical, sexual, or in any other format, that ability to screen effectively under the time limits imposed, particularly by the legal aid agency in MIAM meetings, is so crucial, and it is probably not valued enough by the legal aid, rates of payment. It's again a sophisticated and complicated, complex skill, and like Stephen, I feel that the fact that domestic abuse is present or has been present in a case at some stage should not in all cases be a reason for it not being suitable for mediation. There is a vast spectrum of domestic abuse, ranging from squabbles that happen at the time of separation, which I think anecdotally, probably in my practice, I've felt in 60 to 70% of cases, there's almost always been some sort of squabble, pushing, shoving, kicking the door, kicking the cat, whatever it might be, around the time of separation. So moving from that sort of situation-based abuse through to what might be a long course of coercive and controlling behaviour, scrutinizing those possible elements of a spectrum and screening cases in that category is really, really difficult. And that's where our training is absolutely crucial. And I think shortcuts in not allowing people to have the experience of working alongside experienced mediators and seeing how they do it, watching other people doing it, having a chance to have a go yourself, but within a contained and supervised environment with perhaps a more experienced mediator present, it is massively important. So, for me, I think that is one of the main focuses and one of the things that I, think about regularly, and which, Stephen's talk has kind of brought to the top of my mind, certainly in terms of, the current challenges for mediators. The more the pressure is on mediation to step up and for cases to be moved away from the court, the more and more crucial that screening process becomes to make sure we only take the cases that we really can help and where we're not going to do more damage than good. And I think that that's really the crucial acid test from my point of view. There's so much more I'd love to say, and I'm sure, Stephen, I hope we'll have a chance to have many more conversations like this. But it's, I think Tracy is also going to perhaps chip in with her thoughts about all the things that you've said. And then I'm sure there's going to be loads of questions from people who are participating. And I'll look forward to joining in with the panel discussion as appropriate. Okay, but thanks again, Stephen. It was amazing. Thank you.
Yeah, no, thank you very much, Stephen. Yeah, thought-provoking. I knew I was going to be asked to say something, so I thought I'll start writing a few notes. 3 pages later, I'm now trying to work out which part of your 45 minutes is, I want to highlight on. So, but first of all, like Jane, I'll explain who I am. Well, apart from being chair of the trust, I was appointed as a magistrate in 1995, so about 28 years now. I'm the Cambridgeshire Family Panel Chair, just coming to the end of my term of that, and I've just become course director for the Judicial College on their Family Panel Chair course. So that's going to be an exciting 5 years potential doing that, looking at things from a different angle. I also sit in crime. I don't just do family work in the magistrates' courts. I've kept my crime ticket, as the judges call them. We don't call them tickets in the lay world, but I do both sides, the dark side and the bright side. You can leave it to yourselves which court you think is dark and which is bright. It does depend on certain days. What my one point that really resonated, well, there's a couple or more actually. I think, however, it's the word adversarial. However much we want it to be inquisitorial, as you say, Stephen, the system is set up to be adversarial just by simple, the family procedure rules, the burden of proof, the fact finding, which is, in other words, it's like a trial. I know we still need to find out what went on, but it's still the way of doing it, and the cross examinations that happen, they just create more harm and more harm. And then the other thing that resonated is, and it's the one thing I dislike most about being a magistrate, is when I tell parents what they should be doing when they can't agree. I know that's my role, but I still prefer it if we can come to an agreement in the room in some way or other. Whether or not I'm not a trained mediator, but there are times when we do have to sit there and go, so what do you really want? How can we get to that then? That sort of conversation. And it's sad that it comes to that time that they've paid the money and they're in that room, and somebody else could have done it, and it would have been a much friendlier and calmer atmosphere, and not as scary as a sterile courtroom. I am looking forward to becoming a mediation champion. I'll do another plug for you, Mike. I'm on a course in early December. I couldn't do one of the first ones because I was on holiday. And I also say that I've also had the great privilege of watching a mediation session. I learned so much, and I take my hat off to all the mediators out there of how calm, cool, and sort of everything was. It was just so, I was just like, how are you not losing your temper at this moment? The mediator, that is. It was just so frustrating at times, but the calmness and the resolution that happened was phenomenal. And like I say, I learned so much. So thank you, Stephen. As with Jane, I could mention so much more in the 3 pages that I took, but I think it's time for questions and answers.
Right, has anyone got their hand up for the first question? If not, I shall go, don't worry. I'm sure there must be someone who wants to, but whilst we wait, I was just saying there was a question came up earlier regarding ways that we could work to help support sort of the marginalised groups in society, the different ethnical groups and so forth. How should mediation and the family court world sort of appeal or support those more effectively? Who wants to go first? Stephen, you're working in Bristol on that one, haven't you?
Yes, and what I tried to, what I did as in my role as a judge, was to have these open conferences for the public, and I was told you're going to be super glued to the seat. You're going to have the angry members of the public coming in to these conferences. You're going to have people who've litigated in front of you. It's going to break down. I had about probably 7 or 8 conferences like that. It's your family court, what could we do better? And yes, I did have, in the front row, there were people from Women's Aid sitting next to Families Need Fathers, both Parents Matter, as they become called. And also, there were regularly 2 fathers who had appeared in court in front of me. And in fact, I had said that I had refused their applications for contact. We never had any problem at all. And I believe that's because of the way we treated them. We treated people with as much respect as we could. I would be there to greet them as they came in. We'd hold them in court, a big courtroom that holds 100 people. And they really worked. And people left having felt engaged. And I just wonder whether that sort of talk involving members of the community, and it could be done by teams, would not be a real incentive for people to want to learn more. And I'm quite sure there would be an interest. Mike, you also did the debate, and a debate with a carefully selected motion and good speakers on either side, as you arranged, Mike. I think it was this time last year. That really works, because it, instead of people having to listen to the likes of me droning on, they have to get involved, and you limit the debate to 10 minutes aside. Any question from the floor is limited to a minute, and you run it a bit like question time. And the other thing I'm very keen on is plays, and I've written plays about family law issues, and they get good audiences. And after you've told the story, and you can do this by teams, you then have the lectures, short lectures, and then you get people involved. You get members of the public to join in, they can contribute and chat. And I really do think that raises the profile of what you're doing. You also have to get the press in, and that is complicated because you never play the press and you never assume that the press will report things in the way that you would want. But it does get the flag flown more clearly. So those are examples of what I would suggest.
I was just going to pick up your concept. The concept of a play is a great one. Dad's Matter in Norfolk have recently done a whole play on the voice of the father and the father's experience going through a separation and divorce, and managed to get hundreds of professionals from the sector to go and watch this play. So it can be a very effective tool to hitting different audiences in the right way. So I think that's a really good idea. And the debate, yes, the debate did stimulate a lot of discussion, and we know other jurisdictions picked up on it. So it is a platform that does make people sit up and think. I question how many mediation websites are written in different languages and things like that. How many mediators actually come from these different communities and are able to communicate? Why shouldn't we have Polish-speaking mediation or Urdu-speaking mediation? These are tools that enable people to communicate comfortably in their own language rather than interpreters. And sitting as a magistrate, we all dread the day when an interpreter comes in, because it slows the whole process down. It stops it being a natural process. So if we can find tools like that, engage with those communities to train new mediators, I think that's a really good one. Just moving on then. So Freddie, you've asked a question regarding inspiration to keep motivated. A lot of people struggled getting the portfolio sorted. And I know, Jane, you've just finished the process with one of our team and working on it with another of our team members. They might want to put their hand up and join the chat here. But the question is, how do you keep motivated as you go through the training?
Well, I've just done the training myself. I did it and I can understand how, certainly when it got to the stage of dealing with the financial training, I think a lot of people found that hard, particularly those who were not experienced in dealing with money and having to deal with legal aid benefits and the child support system. Those were the three that really caused problems. I came out of the training feeling that I'd really expanded my knowledge, and so I think trust the trainers, because they are certainly, the trainer I had was really good, Jackie Norton. And there are going to be difficult points, but that's part of the process. You've got to go through that. There's no simple way to educate yourself. It's a bit like being at university. You've got to take exams. But the overall benefit, keep the overall benefit in clear perspective. And remember what you want to achieve. And it's back to this point about look at what you want to achieve and work backwards. So if there are difficult points while you're training, just remember that it's all for a purpose. And what you aim to achieve is that you can get into mediation so that you can then join the ranks of those who are providing this invaluable service. That's my advice.
Jane, what's your experience?
I think that it's such putting together the legal aid agency portfolio for the Family Mediation Council full accreditation is it's an excoriating process. It takes 2 to 3 years. Most mediators that go through it think about giving up at various points along the way. And my job is often, more to do with encouragement. And as Stephen has just, absolutely put his finger on it, look at what you want to achieve. Look at where you're going to be in 3 years' time, 5 years' time, 10 years' time. What is your long-term plan? Do you want to become a supervisor in due course? Because, this is the starting point. If you get these skills and strategies under your belt and you're lucky enough to be able to work with experienced accredited mediators alongside them in a co-mediation format for a year or two, then grab every opportunity, absorb those skills, watch how other people do it, listen to how different situations get handled, and absorb all of that, because you're going to be so grateful later on. And I think my experience has been watching mediators grow through that accreditation process. Often my mediators come in, they're my mediators when they're under my wing and my protection. They're often a bit like rabbits caught in the headlights. Oh my God, I just got to the top of my profession before I changed to do this. And now, as Stephen says, I'm at the start of a new school in the bottom year with people who are cleverer than I am and better at doing everything than I am. And I'm feeling de-skilled. The things that came naturally and automatically to me in my previous job, those things still matter and they're incredibly important, but you have to build this extra layer of skills on top of what you already know. And then you open up this wonderful world where you actually can use everything you've got, drawing on your experience from your past job or occupation, your personal life, as a parent, as a child, as a sibling, and so on. And you might, to really sum up, I think what you're aiming for as a mediator, you're aiming to use everything you've got to channel into the skills and strategies that you can bring to help a family in trouble to move forward in a positive and constructive way as possible. And I think if I can keep my trainee mediators focused on that task, then eventually they get through and they do pass, and it takes time and it's absolutely excoriating, as I've said. But once they've got there, they realise how far they've come. It's very difficult, like with any exam or assessment process, to realise how far you've come until you've got to not the end of the journey. You never get to the end of that journey, but you've got to a point where a crossroads point where you can stop and look back at how far you've come. So, it's all about, having support and encouragement along the way and being reminded about the reason that you're doing it.
Thank you. Karen, you got your hand up. Got a question for us? Muted.
I'm now off the mic. Thank you. Mike, thank you. And Jane, I hope you haven't put poor Stephen off there. He's still here and he looks like he's not going anywhere. I have absolutely no doubt you've been a wonderful judge, and I think you'll be a terrific mediator. Where can we find you?
I'm tempted to say in the local pub. No, but you'll find me. I'm actually going. I've just joined the chambers where I'm sitting at the moment, 3PB. So that's the easiest way to find me. 3 paper buildings. So, okay. But that's very kind of you to ask. Thank you.
And did you say you've completed the foundation training for the second time?
Yes, yep. That's right. Okay. I trained when I was a barrister, and there's a question about barristers and the roles they play. I can see on the chat. It's quite an interesting question, if I may say. Thank you. But yeah, I worked as when I was a barrister. I trained in Bristol and did financial mediation and also children mediation. And then I took silk, and it just became impossible, because I left silk at the time that I had 35 boxes of papers in my room, and I couldn't see the windows. And I just thought, this is a heart attack waiting to happen. So while I was working as a silk, there just wasn't time, I'm afraid, to do mediation as I'd like to. So yeah, that's my history.
So 3PB, which is great, and presumably you've put yourself on the Family Mediation Council register, or that's going to be the thing you do before the end of the day.
Yeah, okay, absolutely.
Okay.
Thank you.
And just to sort of track back on the aspiring family law barrister, I think what's been particularly refreshing for someone who now works exclusively as a mediator and parenting coordinator, but within a law firm, is actually the recognition of lawyers that work in the out of court space, providing early neutral evaluations, private FDRs, etc., and their own ranking in the directories, which hitherto had said a real Rottweiler will fight to the death, etc., etc. So, you know, these changes are perhaps taking longer than we would ideally have wanted, but they're definitely now happening.
Yeah. There seems to be an idea that some have, that all lawyers are innately devoured by the wish to be adversarial in court. I mean, I know what it was like when you're on your feet and you've got instructions from behind, and you just think, I'm being asked to argue something that's absurd. It's horrid. And if the whole environment, the whole atmosphere in court were to be less adversarial, it would be much easier for the advocate actually to put forward the case in a way that's attractive. So I also am pleased that barristers are now being seen as having a great deal to contribute to helping people avoid proceedings. And this image of the lawyer as being driven by a desire to be as offensive as possible in court is just completely mistaken. That's a thing of the past.
Well,
we've had. Sorry, Karen.
I was going to say, you know, some people that are not very solution focused are still out there, but I hope their numbers are reducing.
But also, as a judge,
I was going to say the same thing. We had a very recent example of a firm who was very clearly discouraging the use of mediation, and referrals were coming to us very clearly saying, this case cannot be mediated before it had reached a mediator. We found, by being very blunt and very clear about the procedure rules and our role, that process has changed. And now we're getting positive referrals. So we had to educate the lawyer, the firm to that. But they are less and less out there, I think. We did have a hand up. Was Gaynor? No?
Yep. Yeah. Is my mic on? Yeah.
Yes, it is.
Hi. First of all, can I say, Stephen, thoroughly enjoyed your talk. My name's Gaynor Walsh. I used to be a family lawyer. In fact, Stephen, I briefed you in a past life about 20 odd years ago.
Oh dear, that was a mistake.
I've been a mediator for a very, very long time. A couple of points I wanted to pick up on. In terms of portfolio, I did mine about 20 odd years ago. Stay motivated. It's absolutely worth it. Just power through it and don't give up on it. And have a good PPC to guide you through it, or other mediators. Link in with other people. I still work full time and run my own service as a family mediator. I've done that for 20 odd years, and I've never, well, some days I've regretted it, but not very often. I'm the eternal optimist, and I really believe that there are excellent family lawyers. We need to work with them, not against them. So bring them into the mediation in terms of getting yourself out to other people. Several years ago, I did a series of training for the judiciary, for mothers' union, for churches, for mums groups, for fathers groups, where we did a role play for people to actually see what a Mayam was and what a mini mediation session was. And I do believe that the public are more aware of mediation, and I do believe that parents don't really want to go to court. I think, Steve, you said something that was very, very interesting when you said, try to ask people to start, where do they want to get to? So instead of people thinking we're locked in conflict, where do you need to get to on the other side of the bridge, and get them to focus on solutions for how they get there. So all I'd say is that I do think that mediation, we're in a completely different place to where we were 25 years ago. And I think it's a very good and exciting place, actually. And, you know, I hope I'll be around working for a bit longer to see it develop. So thank you very, very much. I've thoroughly enjoyed it. And James, lovely seeing you. And I've enjoyed your contributions as well.
Thank you. So any comebacks on those? Because I just wanted to otherwise move on to asking about the low-income families. It's my drum I keep banging on to. What ADR solutions are there for those on low income? Is there any way they can move forward if it's not through mediation?
Okay, my answer to that is I think as professionals we need to offer a service, and I've said right from the start when I set up with Frida, and Frida Gardner's the same, that we will offer a service across the board. What I personally don't want to be involved in is a sort of private hospital affair where you only take the rich and famous. I'm just not interested in doing that. So my own view is that we have to be prepared to help people in some mediations, even if they're not funded in the same way, and we have to see that as the quid pro quo of dealing with those who are better off. I think otherwise people who've got no money will go to court, and in court they're not many of them won't get legal aid, and they will not be able to conduct their cases to their best advantage on their own, because they don't know how to. How can they? It's a bit like giving person a penknife and asking them to do surgery on themselves. It just doesn't work. That's my view.
Tracy, what's your experience in the magistrates' courts?
Mine.
Yeah, in magistrates' court, the majority of people on the low incomes will obviously be litigants in person, and so they're in a system that they don't understand. They've often got there because their friends, they've seen it on TV, that's where they should be. And again, this goes back to sort of publicising the benefits of somebody's Karen, you've got your speaker on still, so I can hear your keyboard. I think it must be you. Sorry. I've got headphones on, so I've got big thump through my head. Thank you. So that's why I was hesitating. No, it's the case when you've got litigants in person, they don't know what they're doing, and we're always, are we actually getting the right result for them? Because we're not the trained mediators. They've got into a place which is probably not the right place for them, but because the current system doesn't allow us to chuck them out, for want of a better term, to the right place, or divert them, that's a better word, divert them into mediation, and then back, you know, if they need to come back into court, then they could come back into court. You know, I was on the President's private law working group, and we were trying to look at ways of changing things without having to change the procedural rules, which would sometimes need legislation to change some of the things that are in there. And it was once a family's in the system, it's very difficult to get them out, and that's what needs changing. Mike, you're on mute.
Thank you. Sorry, Alison. But you're on mute now, Alison.
There you go. Can you hear me now?
Yeah.
Right. No, it was just that point about sort of the matching up, the support for litigants in person, when they're in mediation. And I'm a little bit sort of banging on a drum again with the CW5. Now, obviously, this was always something that was really useful for parents and couples in mediation to come along and to say, right, you need to go off and get some legal advice around the issues and the options that you've kind of talked about. And of course, when you had a legally aided client, you could point them in the direction of a solicitor who would do some CW5 work, help with mediation certificates. And when I was a solicitor, I was doing those, pieces of work as a solicitor for my local mediation service. Now, it's like hen's teeth out there. You cannot get solicitors to do that work. It's still there. It's on the legal aid calculator as an attachment. So this is my kind of big beef, that we could join up those good family lawyers that Gaynor mentioned to give that pivotal advice, during mediation, so that we can get more parents and more couples to the end of where they want to be, with the fact that they've had some advice along the way and they haven't been, sort of having to pay expensive lawyers' fees for that. So that was just my point. I don't know if that's makes sense to most of you.
No, it's very helpful. It's an interesting one, and there's talk about the role of legal aid. We have the vouchers in mediation, and recently in the Family Justice Board conference, talking to them about the role of the voucher. I said, yes, but the legal aid is the only tool that these low-income families actually can use, and we have the tool there. And if you just increased the resources, so more mediators are engaged with it, and if you enabled the threshold to be slightly higher, those families would be helped in a far greater way than we currently have. We also have tools like the legal help one, help with mediation. We're just not using because there's not enough money in the pot for anyone to justifiably do it. And I don't think any cases go through it annually now. Yet we're trying to create new things when we have the tools already there. When we do look at the system, and Stephen's picked up a number of ways the system could be changed or developed, we're scared of changing the big things. It's tinkering around the edges. And actually, I think it's possibly a time when a major change is likely to be on the horizon. And I know the Pathfinder project is now about to be rolled out to Cardiff and Birmingham, and the ministers are very keen to see that rolled out across the country very quickly. So there will be some changes coming, but I'm just worried about where and how some of them are going to be impacting us all in being able to carry on supporting the families that need it the most. And I think they're the ones we have to think about, the kids that are going through mental health challenges because of their family's divorce. That's the stuff we've got to really start thinking about. How do we help these people? But on that note, it's 4:30, so that's the time we're due to finish, as we've still got the rest of the AGM to finish. So I would like to thank Stephen for his support, and Jane and Tracy. It's been really helpful, and thank you all for joining us. This is 40 years for the Family Mediation Trust. I'm hoping that we'll be here in another 40. And what tools, techniques and approaches and issues and challenges we are facing in 40 years from now, it will be staggering. Just to think back, we weren't using mobile phones when the trust started. So there's a lot that's going to happen. AI will tell us the solutions, I'm sure. But thank you all. Happy for Tracy, if you want to say anything before we just finish off.
Thank you, Mike. Yeah, thank you to all who have attended today, to Stephen for the extremely thought-provoking lecture, to Jane for joining me on the panel and answering questions far better than I can about mediation, because I'm not a mediator, and to Mike for his usual exceptional planning and preparation for today's meeting.